Mark, and I am the co-director of KW Land for Keller Williams Realty. And today we're going to be going over the Texas Farm and Ranch contract promulgated by TREC. Just so you know, I'm not an attorney. This is my opinion on the contract, how I interpret the contract. If you do have questions about what I'm saying, I recommend talking to a real estate attorney about this. So, want to get that out there. If you do have any questions going forward, you're more than welcome to email us at land@kw.com or reach out to a real estate attorney. So let's go ahead and get started. Parties. The parties to this contract are the seller and buyer. So you put their information there. Seller agrees to sell and convey to buyer, and buyer agrees to buy from seller the property defined below. The land, improvements, accessories, and crops, except for the exclusions and reservations, are collectively referred to as the property. 2A, land. The land situated in the county or counties of, so whatever the property is you're selling or buying for a client or for yourself, you put the counties here. Described as follows. So here you can put legal descriptions of the property, or if it's easier, if there's multiple legal descriptions. So sometimes you're selling a ranch that has 7 to 10, 15, 20 parcels of land in it. What I would typically do is put in Exhibit A right here. So, and then I'll add an exhibit, paragraph 22, which we'll get to for the Exhibit A. And how I do that is we would use MapRight. I will print out a map of the property from MapRight, put it into a Word document, and then put all of the legal descriptions on that form, have the buyer and seller both sign it. As it says right here, or is described on attached exhibit, also known as, you can put the address here. And so together with all rights, privileges, and appurtenances pertaining thereto. Improvements, farm or ranch improvements. The following permanently installed and built-in items: windmills, tanks, barns, pens, fences, gates, sheds, outbuildings, and corrals. Residential improvements, any houses, garages, and all their fixtures and improvements attached to the above described real property, including without limitation the following permanently installed and built-in items, if any: all equipment and appliances, valiances, screens, shutters, awnings, wall-to-wall carpeting, mirrors, ceiling fans, attic fans, mailboxes, television antennas, mounts and brackets for televisions and speakers, heating and air conditioning units, security and fire detection equipment, wiring, plumbing and lighting fixtures, chandeliers, water softener system, kitchen equipment, garage door openers, cleaning equipment, shrubbery, landscaping, outdoor cooking equipment, all other property attached to the above described real property. So this is a very important paragraph of the contract. As you'll see right here, mounts and brackets for televisions. The television would go because it's not attached to the property, but the mounts and brackets are. They are screwed into the wall. So you want to make sure you go through this with your client before. Typically, when you're listing the property, there is a part on the listing agreement that talks about exclusions of improvements and accessories. What we've ran into before is there's a antique item from the family that is in the house. It could be a chandelier, it could be a whatever's attached to the property, right? So what we would do is we'd tell our clients, hey, you need to get rid of that before you put the property on the market, because a lot of the time someone will walk into that property, they'll see that beautiful chandelier, they'll see something of that property that's attached, love it, and then once you try to exclude it, then it becomes an issue. So what we'll typically do is ask them if there are any valuable items that they love about the property that they want to keep, replace them before the property is listed. And obviously, there's some of the things they won't. So, mounts or brackets for television, speakers, anything like that that they want to exclude, they're going to need to exclude that, because as of now, those residential improvements are attached to the property. Have them read over this, make sure they understand what they're reading, and make sure if there is an exclusion, you add it to it. Accessories, farm and ranch accessories. The following describe related accessories. Check boxes of conveyed accessories. So if you're representing a buyer, this is where if any of these items you see on here, your buyer wants, you want to check those boxes. If there's hunting blinds on there, game feeders, livestock feeders or troughs, irrigation equipment, fuel tanks, anything on there, if that's going to convey with the property, it needs to be checked. Residential accessories. The following describe related accessories, if any: window air conditioning units, stove, fireplace screens, curtains and rods, blinds, window shades, draperies and rods, door keys, mailbox keys, above ground pools, swimming pool equipment, maintenance accessories, artificial fireplace logs. I've seen those taken from a house, and I've seen them have to be brought back because they were not excluded. security systems that are not fixtures, and controls for garage doors, entry gates, and other improvements and accessories. Controls include seller's transferable rights to the software and applications used to access and control improvements or accessories, and hardware used solely to control improvements or accessories. Then we go to crops. Unless otherwise agreed in writing, seller has the right to harvest all growing crops until delivery of possession of the property. So we've gone over improvements, we've gone over accessories, and we've gone over crops. So here's the exclusions. The following improvements, accessories, and crops will be retained by seller and must be removed prior to delivery of possession. If there is anything on there that your seller is wanting to retain, we need to exclude it. If they've planted a crop, they have the right to harvest that crop until possession of the delivery of possession of the property, but we need to exclude those on here. Reservations. Any reservations of oil and gas or other minerals, water, timber, or other interests is made in accordance with an attached addendum. So there is an addendum for those. There's a reservation of oil and gas and other minerals addendum. There's the timber addendum. So anything of the reservations need to be added to the contract on another addendum. And then you would add that to paragraph 22, which we'll get to. Sales price, cash portion of sales price payable by buyer at closing. This is what they're putting down as their down payment. The term cash portion of the sales price does not include proceeds from borrowing of any kind or selling other real estate except as disclosed in this contract. Sum of all financing described in the attached. If it's a third-party finance addendum, a loan assumption addendum, seller financing addendum, whatever they're financing would go right here. Then obviously you add both of those up, comes up to the total sales price right here. The sales price will or will not be survey required by paragraph 6C. If the sales price is adjusted, the sales price will be adjusted based on the difference between blank acres and the acreage set forth in the survey required by paragraph 6C. The difference in acreage, either increase or decrease, shall be multiplied by the sum of blank per acre and either added to or subtracted from the sales price stated in paragraph 3C. If the sales price is adjusted by more than 10%, either party may terminate this contract by providing written notice to the other party within blank days after the terminating party receives the survey. If neither party terminates this contract, or if the variance is 10% or less, the adjustment will be made to the amount in 3A, 3B, or proportionally to 3A, 3B. So this is a very important part of the contract as well. If you're selling big acreage properties, you want to know what you're buying. If you're representing the buyer, you want to know what you're selling if you represent the seller. And so, where we see this a lot come into play is if a boundary of the property is a stream, river, creek, those can move. And so you want to make sure that what you're buying is what you're getting and vice versa. And so one example is we sold a property one time that we had a survey and we sold the property, and it was around 126 acres. And the sales price was adjusted. We were representing the seller. It was adjusted based on the survey, but we did have a survey that we talked to the seller about it. He was okay with it. He was okay with signing that, knowing that it will be adjusted. And so we updated the survey. It came back in at about an acre and a half less. And so we communicated this with the surveyor. What happened was the creek had shifted over the past 15 years, which gave up some land. And so the sales price was adjusted based according to the survey, the updated survey. So this is a really important part of the contract. One thing I will comment on per acre, it's up to you, but what we typically do is not. So if the sales price is a certain amount, say it's $1 million, and it's 100 acres, and there's a house on it and a barn and all that stuff, right? We're not going to adjust the price per acre according to $10,000 an acre, because that includes the improvements. And so we would work with our clients saying, okay, here's the value we give the acreage. So say it's 5,000 an acre that we're given the land. So that's 500,000. Additional 500,000 is the improvements. We would only adjust the contract at $5,000 per acre instead of the whole sales price. So we're going just off of land. This has nothing to do with the improvements of the property. Except as disclosed in this contract, seller is not aware of any leases affecting the property After the effective date, seller may not, without buyer's written consent, create a new lease, amend any existing lease, or convey any interest in the property. So if there's any residential leases on the property, if there's any mineral leases, fixture leases, anything like that, surface leases, they cannot amend, they cannot add anything. And so you got to make sure you're aware of that. Residential leases. The property is subject to one or more residential leases, and the addendum regarding residential leases is attached to this contract. You know, if there's a big if you have a big farm or big ranch and there's a couple houses on there and you're leasing those out to people, has to be disclosed. Fixture leases. Fixtures on the property are subject to one or more fixture leases. For example, solar panels, propane tanks, water softener, security system, and the addendum regarding fixture leases is attached to this contract. Natural resource leases. Natural resource leases mean an existing oil and gas, mineral, water, or other natural resource lease affecting the property to which seller is a party. So if any of those are on there, we need to make sure those are checked. If it's a natural resource lease, it says seller has delivered to buyer a copy of all the natural resource leases, or seller has not delivered to buyer a copy of all the natural resource leases, and seller shall provide a buyer a copy of them within 3 days after the effective date. A buyer may terminate the contract within blank days after the date the buyer receives all the natural resource leases, and the earnest money shall be refunded to buyer. Surface leases mean an existing lease for the surface only of the property. So for example, grazing leases, hunting leases, agricultural leases, wind leases, recreational, solar, timber, forestry leases. Seller has delivered to buyer a copy of all the written surface leases, or seller provides buyer with a notice of the following oral surface leases, identifying the type of lease, name of the tenants, rental amount, and term. So if they don't have a actual written lease and they have their buddies out there saying they can hunt the property for the next 2 years, or they pay them $5,000 an acre or whatever it is, that is an oral lease and needs to be disclosed. Seller has not delivered to buyer all surface leases, whether written or oral. Seller shall provide to buyer a copy of all the written surface leases and notice of all oral surface leases, identifying the type of lease, the name of the tenants, rental amount, and term within 3 days after the effective date. Buyer may terminate the contract within blank days after the date if they have not received it. So if you know that that seller is, if you represent the buyer, you know that seller is leasing that to his buddies to hunt, or he's leasing it for some other reason, check box 3, and you want to know what that is if they haven't told you yet, right? So you want to understand what you're getting into, what type of leases are on there, whether they are a written lease or an oral lease. You need to know that for your buyer, and also as a seller, you need to make sure you disclose that if that's the case. Earnest money and termination option. Within 3 days after the effective date, buyer must deliver to escrow agent, which is the title company, at their address, earnest money and option fee money. The earnest money and option fee shall be made payable to escrow agent and may be paid separately or combined in a single payment. Buyer shall deliver additional earnest money of blank to escrow agent within blank days after the effective date of this contract. If the last day to deliver the earnest money, option fee, or the additional earnest money falls on a Saturday, Sunday, or legal holiday, the time to deliver the earnest money, option fee, or the additional earnest money as applicable is extended until the end of the next day that is not a Saturday, Sunday, or legal holiday. The amount escrow agent receives under this paragraph shall be applied first to the option fee, then to the earnest money, and then to the additional earnest money. Buyer authorizes escrow agent to release and deliver the option fee to seller at any time prior without further notice to or consent from buyer, and release escrow agent from liability for delivery of the option fee to seller. The option fee will be credited to the sales price at closing. Termination option. For nominal consideration, the receipt of which seller acknowledges in buyer's agreement to pay the option fee within the time required, seller grants buyer with the unrestricted right to terminate this contract by giving notice of termination to seller within a certain amount of days after the effective date of this contract. Notice under this paragraph must be given by 5 p.m. local time when the property is located by the date specified. If buyer gives notice of termination within the time prescribed, the option fee will not be refunded, and the escrow agent shall release any option fee remaining with escrow agent to seller, and any earnest money will be refunded to buyer. So make sure that if you have an option period for your buyer, something goes wrong, they don't want to buy the property anymore, it is by 5 p.m. local time on the last day of the option period. You need to get over the termination and the release of earnest money. failure to timely deliver earnest money. If buyer fails to deliver the earnest money within the time required, seller may terminate this contract or exercise seller's remedies under the paragraph 15 or both by providing notice to buyer before buyer delivers the earnest money. So after those 3 days, if you're representing the seller, the buyer still hadn't deposited that money, make sure you let your seller know and let them know, hey, if you want to go another route, we have an option. They can stay in the contract if the buyer's delivering it the next day and there's communication, but just make sure that your seller knows if that earnest money has not been deposited. Time is of the essence for this paragraph, and strict compliance with the time for performance is required. Title policy. Seller shall furnish to buyer at seller or buyer's expense an owner policy of title insurance issued by the title company in the amount of the sales price dated at or after closing, insuring buyer against loss under the provisions of the title policy, subject to the promulgated exclusions, including existing building and zoning ordinances and the following exceptions. If you want to know what that title policy cost, you can just Google title policy calculator for Texas. There are title companies that haven't been brought up. You can put the sales price in there, and it is a formula to where you will get what the title policy cost. So when you're negotiating that, you can get an accurate number. So the following exceptions: the standard printed exception for standby fees, taxes, and assessments, liens created as part of the financing described in paragraph 3, reservations or exceptions otherwise permitted by this contract or as may be approved by buyer in writing, the standard printed exceptions as to marital rights, the standard printed exception as to water, tidelands, beaches, streams, and related matters, the standard printed exceptions as to discrepancies, conflicts, shortages in area or boundary lines, encroachments or protrusions, or overlapping improvements. Will not be amended or deleted from the policy, or will be amended to reach shortages in the area at the expense of the buyer and seller. The exception or exclusion regarding minerals approved by the Texas Department of Insurance. So right there on number 6, I would always recommend that you will amend to reach shortages in areas at the expense of either the buyer or the seller. That's a very important thing. It allows the title company to ensure the boundary lines on the legal description going forward. So if you did have a discrepancy in 5, 10, 20 years when you're selling the property, and there is a difference in that acreage, or if there's discrepancies or conflicts on boundary lines or encroachments, protrusions, you can work with the title company you bought it from, or bought it through, with this. And so that's very important. If you're representing the buyer, I would always ask the seller to pay for it. If the seller doesn't want to pay for it, I'd always recommend my buyer to buy it. Commitment. Within 20 days after the title company receives a copy of this contract, seller shall furnish to buyer a commitment for title insurance, and at buyer's expense, legible copies of restrictive covenants and documents evidencing exceptions in the commitment other than the standard printed exceptions. Seller authorizes the title company to deliver the commitment exception documents to buyer at buyer's address shown in paragraph 21. If the commitment exception documents are not delivered to buyer within the specified time, the time for delivery will be automatically extended up to 15 days or 3 days before the closing date, whichever is earlier. If the commitment exception documents are not delivered within the time required, buyer may terminate this contract and the earnest money will be refunded to buyer. So make sure you stay on top of the title company and they're honoring that and getting there within 20 days. The survey must be made by a registered professional land surveyor or acceptable to the title company and buyer's lender. So there's a couple options here. So if you know that there's a survey, if you're representing the buyer and you haven't received it yet, obviously we're going to check box 1. Within a certain amount of days after the effective date of this contract, seller shall furnish to buyer and title company seller's existing survey of the property and a residential real property affidavit promulgated by the Texas Department of Insurance, which is the T47 affidavit. If seller fails to furnish the existing survey or affidavit within the time prescribed, buyer shall obtain a new survey at seller's expense no later than 3 days prior to the closing date. What I've seen before is a seller will take the survey and the T47 and send it to the title company, or the listing agent will send it to the title company, right? Say you had within 3 days. Within those 3 days, it's sent to the title company. Well, the 4th day comes around The buyer said, well, where's the survey? Seller says, well, I sent it to the title company. Well, I don't have the survey. It's not the title company's responsibility to send it out at that point. So what happens? The seller is responsible to provide a new survey, because up here it says seller shall furnish to buyer and title company seller's existing survey. So as a listing agent, you want to make sure that you send it to the title company and to the buyer's agent. And if the buyer's email's on there, I'd go ahead and send it to them as well. It should be in paragraph 21 down below. Very important. The existing survey will or will not be recertified to a date subsequent to the effective date of this contract at the expense of the buyer and seller. If you have a question on that, you can call the survey company that did the survey, and they will be able to give you an idea of what it costs to recertify that, to bring it up to date, to make sure all the information is correct. And then you can determine if the buyer or seller is going to pay for that. If it's a current survey or a survey done recently, you may not need this. That is the discretion of you and your client. If the existing survey is not approved by the title company or buyer's lender, a new survey will be obtained at the expense of the buyer or seller no later than 3 days prior to closing date. Once again, this is negotiable. It's up to you to determine who's going to be paying for that. If you've seen the survey, you know that there's a structure built on there that's not on the survey when the survey was done. And say you represent the buyer, the survey doesn't have it on there, but the listing agent thinks that they're okay. We'll go ahead and put the seller here. It's negotiable, right? So it just depends on every circumstance is different. So it depends on how you look at the survey, but it's up to y'all to decide who's going to pay for it if it does not work. If there is no survey, then it's going to either be box 2 or 3. Within a certain amount of days after the effective date, the buyer shall obtain a new survey at the buyer's expense, or within a certain amount of days after the effective date of this contract, at seller's expense shall furnish a new survey to buyer. Once again, negotiable. No survey is required. I don't really want to get into that, but I would definitely look that up. I would look up when a survey is not required on a real estate contract in Texas. Cash does not require a survey. Most of the time, it is required by lenders to have a survey. So there's some other ways that it's not required, but I would look that up at your own time. Objections. Buyer may object in writing to defects, exceptions, or encumbrances to the title disclosed on the survey other than items 6A 1 through 5 above, which you can go back up and read those, or disclosed in the commitment other than items 6A 1 through 7 above. Any portion of the property lying in a special flood hazard area, as shown on the current Federal Emergency Management Agency map, or any exceptions which prohibit the following use or activity. Sometimes people put in there residential use, recreational use. This is a question for your attorney. I would ask them about this. If there's any type of use that you want to put in there, definitely reach out to an attorney and get that advice from them. Buyer must object the earlier of 1, the closing date, or 2, blank days after buyer receives the commitment. So I would always, if your buyer wants to review the title commitment, review the survey, review the exception documents, and if there is something wrong with those, they can object to it, but you need to make sure there's a certain amount of days in there. So, 7 days, 10 days, whatever you're comfortable with, or your client's comfortable with reviewing those documents. Most of the time, you'll see that that client is sending those documents to an attorney to review. Depending on how long it takes them to review them, is how many days you need to put in here. So make sure that you do not miss this part, because that is just another way out for a buyer. If you represent a buyer, if something does happen, you can use this to get out of the contract. For example, I had a property in contract a year or two ago. It was a REO property, and it was supposed to be a quick close, very strict contract. But I did have an objection period in there. We didn't have a survey yet, so we had to get a survey. I was past my option period, so I couldn't use that as a back out. It was a cash deal, so I didn't have any financing terms to back out on. But once I saw the survey, I saw that there was encroachment on the survey, and so I objected to the survey, and was able to get a lot of. I had to put like 50% earnest money down, so it was a lot of money. Um, and I was able to object to the survey, and they could not fix it because the property that was it was going on to was an illegal dispute. So I was able to back out of that deal because I was able to object to the survey, which is important to have. Buyer's failure to object within the time allowed will constitute a waiver of buyer's right to object, except that the requirements in Schedule C of the commitment are not waived by buyer. Provided seller is not obligated to incur any expense, seller shall cure any timely objections of buyer or any third-party lender within 15 days after seller receives the objections, which is the cure period. Cure period and the closing date will be extended as necessary. If objections are not cured within the cure period, buyer may, by delivering notice to seller within 5 days after the end of the cure period, terminate this contract and the earnest money will be refunded to buyer or waive the objections. So it's at that point your choice. Do you want to back out of the deal or just waive the objections and go forward with the sale? If buyer does not terminate within the time required, buyer shall be deemed to have waived the objections. So if you don't, then all of a sudden you're back in contract and you cannot use the objection paragraph to back out. If the commitment or survey is revised or any new exception documents is delivered, buyer may object to any new matter revealed in the revised commitment or survey or new exception documents within the same time stated in this paragraph to make objections beginning when the revised commitment, survey, exception documents is delivered to buyer. So if you object to the survey, something's wrong on it, you object to it, they fix it, they get you the updated survey. It states here the objection period can start back over and make sure that there's nothing else to object to. Exception documents. Prior to the execution of this contract, seller has provided buyer with copies of the exception documents listed below or on the attached exhibit. Matters reflected in the exception documents listed below or on the attached exhibit will be permitted exceptions in the title policy and will not be a basis for objection to title. You could put a document on if the seller owns the minerals, if there's a right below a surface lease, if somebody is mining something off the property, anything like that, the buyer knows it. You may want to record that onto this exception document paragraph so they cannot use that as an objection when you get down the road and get the title commitment, because it will come up on there. So you want to make sure you put the document, the date the document is filed, and the recording reference. I would definitely talk to an attorney about this as well, because this can get kind of gray in some areas. Surface leases. The following surface leases will be permitted exceptions in the title policy and will not be a basis for objection to title. This could be the same thing if they're mining on the property, they're digging rock out, or there's a company that has built something on part of the ranch, right? But they have a blanket lease on the whole entire ranch as a surface lease. Um, your buyer may not know that they can come on to another part of the property. Say it's 500 acres and they're selling 200 acres of it. Over on that 300 acres, they have built a facility or they're mining over there, but they can go on the 200 acres. If the buyer doesn't know that, that could be a problem. And so you want to make sure that that's on here and it's being disclosed. Title notices, abstract or title policy. Broker advises buyer to have an abstract of title covering the property examined by an attorney of buyer selection, or buyer should be furnished with or obtain a title policy. If a title policy is furnished, the commitment should be promptly reviewed by an attorney of buyer's choice due to the time limitations on buyer's rights to object. So it's always good for an attorney, especially on farm and ranch properties. There's a lot that goes into them. There's a lot that may not be seen. Hire an attorney is a very, very beneficial thing for your client to do, to review all these documents, because there's a lot that goes. It's not just a standard house in a subdivision. It could be 5 or 10 acres. It could be 5,000, 10,000 acres. It doesn't matter. The bigger when there's land involved, there's things that could go wrong. And so it's always important to get an attorney to review that stuff for your client, or your client have their attorney review it. Statutory tax districts. If the property is situated in a utility or other statutory created district providing water, sewer, drainage, or flood control facilities and services, Chapter 49 Texas Property Code requires seller to deliver and buyer to sign the statutory notice relating to the tax rate, bonded indebtedness, or standby fee of the district prior to final execution of this contract. If you don't know if your property is in that, talk to your seller, look up chapter 49 of the Texas Water Code, make sure you understand what that is. Tidewaters. If the property abuts the tidally influenced waters of the state, 33.135 Texas Natural Resource Code requires a notice regarding coastal area property to be included in the contract. An addendum containing the notice promulgated by TREC or required by the parties must be used. There is an addendum that has that language on there for Tidewater. So go find that if your property is abuts the tidally influenced waters of the state, you want to make sure you have that on there and attached to the contract. Annexation. If the property is located outside the city limits of a municipality, sellers notify buyer under 5.011 Texas Property Code that the property may now or later be included in the extraterritorial jurisdiction of a municipality, which is the ETJ, and may now or later be subject to annexation by the municipality. Each municipality maintains a map that depicts its boundaries and extraterritorial jurisdiction. To determine if the property is located within a municipality's ETJ or is likely to be located within a municipality's ETJ, contact all municipalities located in the general proximity of the property for further information. This is going to be something that we will see more and more of as Texas continues to grow. You see these cities growing out and getting bigger. They're annexing land in the county into the city because there's so many people moving here. So if you're selling land around cities, this is something you need to be aware of. And so if you're contacting those municipalities and talking to them about their ETJs, and you need to know that and make sure that if you're selling a property and they've been notified or something that their property could be annexed in, that has to be disclosed to the buyer. So you need to make sure you're aware of that. Property located in a certificated service area of utility service provider. Notice required by 13.257 Water Code. The real property described in paragraph 2 that you are about to purchase may be located in a certificated water or sewer service area, which is authorized by law to provide water or sewer services to the properties in the certificated area. If your property is located in this area, there may be several costs or charges that you'll be required to pay before you can receive water or sewer service. There may be a period required to construct lines or other facilities necessary to provide water or sewer service to your property. You are advised to determine if the property is in a certificated area and contact the utility service provider to determine the cost that you'll be required to pay and the period, if any, that is required to provide water or sewer service to your property. The undersigned buyer hereby acknowledges receipt of the foregoing notice at or before the execution of a binding contract for the purchase of the real property described in paragraph 2 or at closing of purchase of the real property. Once again, in rural areas, there may not be water or sewer readily available, so there may be a utility service provider out there, and so you need to be aware of that and make sure that you understand, your buyer understands there could be a cost to get water or sewer there. Once again, you have to look up the property code 13.257 Water Code. Get familiar with this stuff, and so that's very important to understand. Public improvement districts called PIDs. If the property is in a public improvement district, sellers must give buyer written notice as required by 5.014 Property Code. An addendum containing that required notice shall be attached to this contract. If it's saying that means there is an addendum in the TREC forms for this. So this would be if some of these developments that are happening outside of city limits, they're creating their own PIDs, and so they're being the homeowners are being taxed on it for those utilities, and so there's a special tax on their tax bill that they'll be getting, and so you need to make sure they're aware of that, the new buyers. Texas Agricultural Development District. This property is or is not located in the Texas Agricultural Development District. For additional information, contact the Texas Department of Agriculture. At the point of this video, there is not a Texas Agricultural Development District in the state of Texas. This has nothing to do with agricultural exemptions. I've seen agents put the property is because the property is ag exempt. That has nothing to do with Texas Agricultural Development Districts. And so as of now, when this video is made, there is not a Texas Agricultural Development District in the state of Texas. You're more than welcome to go onto the website for the Texas Department of Agriculture to find that out. But I just want to make sure you understand this has nothing to do with your property being ag exempt. Transfer fees. If the property is subject to a private transfer fee obligation, 5.205 Property Code requires seller to notify buyer as follows. The private transfer fee obligation may be governed by Chapter 5, Subchapter G of the Texas Property Code. Once again, look these up. Get familiar with them, understand what they're talking about. Propane gas system service area. This is another one that gets people confused. If the property is located in a propane gas system service area owned by a distribution system retailer, seller must give buyer written notice as required by 141.010 Texas Utilities Code. An addendum containing the notice approved by TREC or required by the parties should be used. This does not mean if you have a propane tank on your property that you are in a propane gas system service area. As of now, this video, I think down there in Travis County, Gillespie County, there's one in Palo Pinto County, but mainly in Central Texas, there are some propane gas system service areas. Other than that, I haven't seen any in the state of Texas. And so make sure you're aware of that. And if you are in one, there is an addendum to disclose that. But once again, if you go to a property and you're looking at a ranch and you go into the side of the house and you see the big, 250, 500 gallon propane tank sitting out on the side of the house where it's giving them propane to heat their house or whatever, that does not mean they're in a propane gas system service area. So I would Google propane gas system service areas in Texas, get more familiar with that because it's mainly just in one central area, but it could expand into other counties. A notice of water level fluctuations. If the property adjoins an impoundment of water, including a reservoir or lake, constructed and maintained by Chapter 11 Water Code that has a storage capacity of at least 5,000 acre feet at the impoundment's normal operating level, seller hereby notifies buyer the water level of the impoundment of water adjoining the property fluctuates for various reasons, including as a result of an entity lawfully exercising its right to use the water stored in the impoundment, or drought or flood conditions. So lakes all across Texas, if it's bigger than 5,000 acre feet at the normal operating level, you need to make sure that they understand this. There are a lot of lakes, at least up here in North Texas. I know down in Central Texas, South Texas, they use to irrigate. They let water out through the dams, go down the rivers. Farmers use that for their crops and their farms. So water will fluctuate on lakes across Texas because of that. And so people need to be aware if they're going out and buying a ranch and there's a farm or a piece of land or whatever, and there's a boat dock out there, right? They come back a week later or 2 weeks later and their boat dock's on dry land. Well, it's because the water's fluctuating, they're letting water out, and so they need to be aware of that. The following notices have been given or are attached to this contract. If it's in a MUD, a PID notices, so anything like that, Google those. Make sure your client will know more than likely if they're in one of those, and so you need to address those when those come up. Property condition, access, inspections, and utilities. Seller shall permit buyer and buyer's agent access to the property at reasonable times. Buyer may have the property inspected by inspectors selected by buyer and licensed by TREC, or otherwise permitted by law to make inspections. Any hydrostatic testing must be separately authorized by seller in writing. There is an addendum for hydrostatic testing, and so if your buyer is wanting that, they'll need to have that filled out. Seller, at seller's expense, shall immediately cause existing utilities to be turned on and shall keep the utilities on during the time this contract is in effect. Okay, so if you're representing the buyer and you're getting the property inspected, I would always recommend, my broker recommends us to give them a few inspectors. Do not give them one inspector. You want to give them an option of inspectors that you've used in the past, or agents in your office use, or your team leader or broker recommends. Always give your buyer a few inspectors to choose from and let them make that choice. Buyers should determine the availability of utilities to the property suitable to satisfy buyer's needs. So, we need to make sure the water's on, the electric's on, and all that. If the gas or propane, make sure all that's on. So when the inspector does come, they're able to inspect everything on the property. Seller's disclosure. Buyer has received the notice or buyer has not received the notice. You need to make sure you understand if you have or have not received the seller disclosure. Within blank days after the effective of this contract, seller shall deliver the notice to buyer. If I'm representing the buyer, I will never put more than probably 2 days on there because they should already have this filled out. It should be something they can get over to me the day we get it in contract. I would not give them a lot of time to get that over. So the buyer is able to review it. If buyer does not receive the notice, buyer may terminate this contract at any time prior to the closing, and the earnest money will be refunded to buyer. If seller delivers the notice, buyer may terminate this contract for any reason within 7 days after buyer receives the notice or prior to the closing, whichever first occurs, and the earnest money will be refunded to buyer. Or the Texas Property Code does not require this seller to furnish the notice. I think there are probably 7 or 8 or so reasons why you would not have to furnish a seller's disclosure in a contract. Once again, I'll ask you to look that up and look up the exceptions for that at your own time. But there are probably 7 or 8 or so that of reasons why you do not need a seller's disclosure. Obviously, if there's no improvements on it, there's nothing to disclose on the improvements, so that would be one of them, but there's others. Seller's disclosure of lead-based paint and lead-based paint hazards is required by federal law for a residential dwelling constructed prior to 1978. So if you're selling a farm or a ranch or a piece of land and there's an old homestead on it that was built before 1978, make sure you have that in there. Lead-based paint addendum. Acceptance of property condition. As is means the present condition of the property with any and all defects and without warranty except for the warranties of title and the warranties in this contract. Buyer's agreement to accept the property as is under paragraph 7D1 or 2 does not preclude buyer from inspecting the property under paragraph 7A, from negotiating repairs or treatments in a subsequent amendment, or from terminating this contract during the option period. This is one I see all the time as well. Sellers, it happens all the time. They will see that the buyer accepts the property as is. So the buyer gets the inspection, he comes back with a repair amendment, and they get all mad because they said, well, the buyer accepted the property as is. It says on the contract they're accepting it as is. Well, yes, they are accepting as is from what they can see about the property. Okay, if they don't see anything wrong with the property, they're accepting it as is, but they still have the option during the option period to get the home inspected. If there's things that come up that they're not aware of, they can still negotiate that. Or buyer accepts the property as is, provided seller at seller's expense shall complete the following specific repairs and treatments. Property, and you walk in the house and the foundation, you just know it's bad, right? There's cracks everywhere, it's falling in. You can put in here, buyer accepts the property as is, provided seller at seller's expense shall complete the following specific repairs and treatments. Have whatever verbiage you want about repairing the foundation, right? There are some things you can put in here that they're very obvious things that your buyer wants, that he will not buy the property without it being fixed. He needs to put it in here. They still can go and negotiate stuff off the inspection. But right here it says, do not insert general phrases such as subject to inspections that do not identify specific repairs and treatments. So if there are specific repairs or treatments that your buyer sees need to be done as a condition to even get it executed, they need to put that in here. If there's nothing they see that needs to be done from the eye, buyer accepts property as is, but they still have the option to go back and negotiate repairs during the option period. Completion of repairs and treatments. Unless otherwise agreed in writing, seller shall complete all agreed repairs and treatments prior to the closing date and obtain any required permits. The repairs and treatments must be performed by persons who are licensed to provide such repairs or treatments, or, if no license is required by law, are commercially engaged in the trade of providing such repairs or treatments. This was new a few years ago. A long time ago, people would, if there was a leaky faucet or a toilet was leaking or something, the homeowner would go in there and fix it. Well, now, according to the contract, it needs to be somebody that has a license to do that or is commercially engaged in such repairs or treatments. So your seller, unless they are licensed or they engage, commercially engage in such repairs, they're not able to do that anymore. They need to hire somebody to do it. Then after that, seller shall provide buyer with copies of documentation from the repair person showing the scope of work and payment for the work completed. And at seller's expense, arrange for the transfer of any transferable warranties with respect to the repairs to buyer at closing. So if you're representing the buyer and you ask for all these repairs to be done, before you go to the closing table with your buyer, you need to make sure that you have received copies of what's been repaired and that it has been paid. If seller fails to complete any agreed repairs prior to the closing date, buyer may exercise remedies under paragraph 15 or extend the closing date up to 5 days if necessary for seller to complete repairs. That is why it's important to do walkthroughs before you close. So if you've asked for these repairs to be done, the morning of closing or the day before closing, you go with your buyer to walk through the property and make sure everything's done. You see something hasn't been done, well, then you notify the seller, you notify the listing agent, and then you may exercise remedies under paragraph 15 or extend the closing date up to 5 days for them to fix those repairs. Then go back and walk through it again, make sure it's correct. The worst thing that would happen is you trust the other agent, and the seller, if you represent the buyer, and say, hey, here's what we want done. All the repairs need to be done. The seller's, yeah, we're good. We'll have all that stuff at closing for you. Well, your buyer goes in and signs all the documentation and is waiting for the seller to come sign. They sign, it closes, and you go over to the property and see that some of the repairs haven't been done. That's a problem. I wouldn't want to be in that situation. All right, lender required repairs and treatments. Unless otherwise agreed in writing, neither party is obligated to pay for lender required repairs, which includes treatments for wood destroying insects. If the parties do not agree to pay for the lender required repairs or treatments, this contract will terminate and the earnest money will be refunded to buyer. If the cost of lender required repairs and treatments exceeds 5% of the sales price, buyer may terminate this contract and the earnest money will be refunded to buyer. So typically you'll see lender required repairs with FHA loans, VA loans, USDA loans. Um, Most of the time, what I've seen is peeling paint, roofs, foundation. There's a lot of things that could go on because the lender will have an appraiser go out, appraise the property. They will see defects of the property. They may not lend on the property unless you do certain repairs. And so that's what this is talking about right here. Environmental matters. Buyers advise that the presence of wetlands, toxic substances, including asbestos and waste or other environmental hazards, or the presence of a threatened or endangered species or its habitat may affect buyers' intended use of the property. If buyers are concerned about these matters, an addendum promulgated by TREC or required by the parties should be used. There is an addendum for this. I recommend going to read it if that is something, if this paragraph pertains to the property you're buying or selling. Seller's disclosure. This is one part of the contract that goes out. Seller is or is not aware of any flooding of the property which has had a material adverse effect on the use of the property. Seller is or is not aware of any pending or threatened litigation, condemnation, or special assessment affecting the property. Seller is or is not aware of any environmental hazards that materially and adversely affect the property. Seller is or is not aware of any dump sites, landfill, or underground tanks or containers now or previously located on the property. Seller is or is not aware of any wetlands as defined by federal or state law or regulation. Seller is or is not aware of any threatened or endangered species or their habitat affecting the property. Seller is or is not aware of the property is located wholly or partially in a floodplain. And seller is or is not aware that a tree or trees located on the property has oak wilt. If seller is aware of any of the items above, please explain. If you can't explain it in this little bitty line right here, obviously you can attach an additional sheet that talks about that. So most of the time on ranches and farms, there will be part of it in the floodplain, or not most, there are several times though, or any of these other disclosures. If the seller says yes, and make sure they fill this out, do not fill this out for them. This is for the seller to fill out. Residential service contracts. A buyer may purchase a residential service contract, which is a home warranty, from a provider or administrator licensed by the Texas Department of Licenses and Regulation. If buyer purchases a residential service contract, seller shall reimburse buyer at closing for the cost of the residential service contract in the amount not exceeding blank. This is negotiable. So once again, if there are home warranty companies you work with, and if your buyer is wanting one, recommend a couple to them. Recommend a couple home warranties to them because they're all kind of different. Let them choose the home warranty they want. You can even do that before you sign this contract, right? And say if they want a home warranty, okay, here's a couple home warranty companies we use. Here's what they offer. Here's the add-ons. There'll be pricing on there. So say it's $1,000. You can ask for the seller to pay that, and what that'll do is cover what's in that home warranty up to a year. And there's other information you can find out through the home warranty how that works. But that's where you'd put this. Buyer should review any residential service contract for the scope of coverage, exclusions, and limitations. The purchase of a residential service contract is optional. Similar coverage may be purchased from various companies authorized to do business in Texas. Government programs. The property is subject to the government programs listed below or on the attached exhibit. If there are any governmental programs the property is in, then you need to make sure that you attach those. Your seller will know. Seller shall provide buyer with copies of all governmental program agreements. Any allocation or prorations of payment under governmental programs is made by separate agreement between the parties, which will survive closing. Brokers and sales agents. Texas law requires a real estate broker or sales agent who is a party to a transaction or acting on behalf of a spouse, parent, child, business entity in which the broker or sales agent owns more than 10%, or a trust for which the broker or sales agent acts as a trustee, or of which the broker or sales agent or the broker or sales agent's spouse, parent, or child is a beneficiary, to notify the other party in writing before entering into a contract of sale. So right here, if I'm going to representing my parents on purchasing a ranch, I need to make sure we put in here that Ben Clark um, is the son of Ben Clark is the son of the buyers, right? You need to make sure you disclose that. Broker fees. All obligations of the parties for payment of broker fees are contained in separate written agreements. We'll get into broker fees here in a little bit. Closing. The closing of the sale will be on or before whatever date it is in the year, or within 7 days after objections made under paragraph 60 have been cured or waived, whichever date is later. If either party fails to close the sale of the closing date, the non-defaulting party may exercise the remedies contained in paragraph 15. One thing to always check here, make sure that date is not on a weekend. I actually got a contract a couple weeks ago on a property from a buyer. I'm representing the seller. They put a date in here. I went and just confirmed. It was on a Saturday. So we are professionals. We need to make sure we catch that. And we change that date to make sure it's a weekday because we're not going to be closing on a Saturday. At closing, seller shall execute and deliver and also they had 2022 in here. And as of this video, we're in 2023. So the date and the year were wrong. So make sure you catch those. At closing, seller shall execute and deliver a general warranty deed conveying title to the property to buyer and showing no additional exceptions to those permitted in paragraph 6. An assignment of leases and furnished tax statements or certificates showing no delinquent taxes on the property. Buyer shall pay the sales price in good funds acceptable to the escrow agent. Seller and buyer shall execute and deliver any notices, statements, certificates, affidavits, releases, loan documents, transfer of any warranties, and other documents reasonably required for the closing of the sale and the issuance of the title policy. There will be no liens, assessments, or security interests against the property, which will not be satisfied out of the sales proceeds unless securing the payment of any loans assumed by buyer, and assumed loans will not be in default. Private transfer fees will be the obligation of seller unless provided otherwise in this contract. Transfer fees assessed by a property owners association are governed by the addendum for property subject to mandatory membership in a property owners association. The title company can help you with all this, most of it. Possession, buyer's possession. Seller shall deliver to buyer possession of the property in its present or required condition, ordinary wear and tear accepted upon closing and funding, or according to a temporary residential lease promulgated by TREC or other written lease required by the parties. So if you're representing the seller and you want a 30, 60-day lease back, if they're going to get farm equipment off or they need to get stuff out of a house, then you will the buyer's possession will be according to a temporary residential lease form that you have attached to the contract, the seller's temporary residential lease. So make sure you're aware of that, whether the buyer gains possession upon closing and funding or if there is a lease in place afterwards. Consult your insurance agent prior to change of ownership and possession because insurance coverage may be limited or terminated. The absence of a written lease or appropriate insurance coverage may expose the parties to economic loss. Make sure that your insurance agent is aware of this. Okay, if they're insuring the property, you close on the property and you're doing a lease back, they need to be aware of that in case there's other types of insurance you need to get, vice versa for the buyer. If you close on that property and you're releasing it back to somebody, your insurance agent needs to know that. Smart devices mean a device that connects to the internet to enable remote use, monitoring, and management of the property, items identified in a non-realty item addendum, or items in a fixture lease assigned to buyer. At the time seller delivers possession of the property to buyer, seller shall deliver to buyer written information containing all access codes, usernames, passwords, and applications buyer will need to access, operate, manage, and control the smart devices and terminate and remove all access and connections to the improvements and accessories from any of seller's personal devices, including but not limited to phones and computers. Pretty self-explanatory. Special provisions, another one that people get kind of messed up. This paragraph is intended to be used only for additional informational items. Any informational item is a statement that completes a blank in a contract form, discloses factual information, or provides instructions. Real estate brokers and sales agents are prohibited from practicing law and shall not add to, delete, or modify any provision of this contract unless drafted by a party to this contract or a party's attorney. This is not a spot for you to put whatever verbiage you want in there on behalf of your buyer or seller. This is not where you put, if you represent the seller to retain minerals. There is an addendum for that. If there is an addendum for anything that you can put in here, put it into an addendum. If your seller or buyer want to add something in special provisions, then you need to make sure it's documented that they're sending it to you, whether preferably through an email, and then you just copy and paste that into the special provisions. Or if their attorney wants to put something in there, they can do that. You are not a party to this contract. You cannot put something in there. That is not your responsibility. That is the buyer or seller or their attorneys. Make sure you know that. And so even if your seller calls you and says, "Hey, I want you to put such and such this in special provision," say, "Okay, that's great. Now, will you please write it out, and I'm going to word for word copy and paste it into special provision so it's coming from you, whether that's through an email, through a text, to make sure you have that recorded, copied. You can put it into your command file, take a screenshot of it, put it in there, just in case anything ever happened. You have your documentation that shows that your seller or buyer gave you that information to put in special provisions." Our broker always used to tell us, documentation beats conversation. So make sure you understand that. Settlement and other expenses. The following expenses must be paid at or prior to closing. Expenses payable by seller, releases of existing liens, including prepayment penalties and recording fees, release of seller's loan liability, tax statements or certificates, preparation of deed, 1/2 of escrow fee, and other expenses payable by seller under this contract. Seller shall also pay an amount not to exceed blank to be applied in the following order: buyer's expenses, which buyer is prohibited from paying by FHA, VA, Texas Veteran Lands Board, or other governmental loan programs, and then to other buyer's expenses allowed by the lender. If you're representing the buyer and they're buying a property and they need closing cost assistance, or they're wanting to ask the seller to pay for some of that, this is where you'd put that. Now, I would recommend you talking to their lender, asking them how much you can put in there, because there is regulations on what actually can be put in there um, to be helped with the buyer's expenses. And so make sure that you're communicating with the lender. So, but that right there is for if you're wanting help from the seller on buyer's closing costs. That's where you'd put that information. So, for example, if you're offering $100,000 for a property, and your buyer's wanting $5,000 closing cost assistance, you'd put $5,000 here. But now that contract, if you're representing the seller, you make sure you're aware. You tell your seller it's pretty much a $95,000 offer now, because you're crediting $5,000 back to the buyer for their closing costs on the settlement statement. So that'll be a deduction on the settlement statement from the seller to the buyer. Expenses payable by buyer: appraisal fees, loan application fees, origination charges, credit reports, preparation of loan documents, interest on the notes from dates of disbursement to 1 month prior to dates of first monthly payments, recording fees, copies of easements and restrictions, loan title policy with endorsements required by lender, loan-related inspection fees, photos, amortization schedules, 1/2 of escrow fee, all prepaid items, including required premiums for flood and hazard insurance, reserve deposits for insurance, ad valorem taxes and special government assessments, final compliance inspection, courier fee, repair inspection, underwriting fee, wire transfer fee, expenses incident to any loan, private mortgage insurance premium, VA loan funding fee, or FHA mortgage insurance premiums as required by the lender, and other expenses payable by a buyer under this contract. A lot of those fees majority of them are lender fees, so you'll be able to get that information from your buyer's lender. If any expense exceeds an amount expressly stated in this contract for such expenses to be paid by a party, that party may terminate this contract unless the other party agrees to pay such excess. Buyer may not pay charges and fees expressly prohibited by FHA, VA, Texas Veterans Land Board, or other governmental loan program regulations. Once again, I recommend you talking to some lenders about this and get that information from them so it's accurate and coming straight from the lenders. Proration and rollback taxes. Prorations, taxes for the current year, interest, rents, and regular periodic maintenance fees, assessments, and dues, including prepaid items, will be prorated through the closing date. The tax proration may be calculated taking into consideration any change in exemptions that will affect the current year's taxes. If taxes for the current year vary from the amount prorated at closing, the party shall adjust the prorations when tax statements for the current year are available. If taxes are not paid at or prior to closing, buyer shall pay taxes for the current year. Rentals which are unknown at the time of closing will be prorated between buyer and seller when they become known. Rollback taxes. This is important. If the sell or buyer's use of the property after closing results in the assessment of additional taxes, penalties, or interest for periods prior to closing, the assessments will be the obligation of the buyer. If the assessments are imposed because of seller's use or change in use of the property prior to closing, the assessments will be the obligation of seller. Obligations imposed by this paragraph will survive closing. For example, rollback tax if the property is an agricultural exemption. I saw this happen a few years ago. We represented the seller. It was being leased to a farmer. It was an agricultural exemption. The buyer comes represented by another agent. He comes and buys the property. He does not renew the lease with the farmer. He doesn't even understand what rollback taxes are. And it was $1 million property, and he got hit at that time. It was 5 years of rollback taxes of what the value of that property was over the past 5 years each year at the current tax rate of that year plus interest. And so he got kicked out of agricultural exemption. He had to go back 5 years and pay rollback taxes, which were probably $50,000 to $100,000, because his agent did not inform him to keep, if he wants to keep that property, because he wasn't using it all the time to develop, part of that property could have been kept in ag exemption, and he would not have had to pay those rollback. And so make sure your buyer's aware of what rollback taxes are. If they go buy a property and they want to keep a horse out there, well, that may not qualify for agriculture exemptions. You need to contact your county tax office or the FSA office, Farm Service Agency office in your county. Let them help them become aware of what qualifies for ag exemptions, mainly for that's what we're talking about because of the farm ranch contract. But there are other ways rollback tax can take place. But the biggest one for farm ranch contracts is agricultural exemptions. So be sure you're aware of that because that could cost your client a lot of money and it'd make you look pretty bad. So make sure you're aware. Casualty loss. If any part of the property is damaged or destroyed by fire or other casualty after the effective date of this contract, seller shall restore the property to its previous condition as soon as reasonably possible, but in any event by the closing date. If seller fails to do so due to factors beyond seller's control, buyer may terminate this contract and the earnest money will be refunded to buyer. Extend the time for performance up to 15 days and the closing date will be extended as necessary, or accept the property in its damaged condition with an assignment of insurance proceeds if permitted by seller's insurance carrier, and receive credit from seller at closing the amount of the deductible under the insurance policy. Seller's obligations under this paragraph are independent of any other obligations of seller under this contract. So if a high winds come through, a tornado comes through and blows shingles off a house or blows a roof off of a barn, that needs to be fixed before closing. So what could happen is if it's an insurance claim and it hasn't been solved by the time closing comes, if it's acceptable to the insurance companies, that those proceeds from that insurance claim could be given to the buyer at closing. They'd be deducted from the closing costs of the settlement statement. So there's ways to go about it, but most of the time it's always best to get that stuff done before closing. We had one a couple years ago, or actually one a couple years ago was last year, that we were going to close. High winds come through, like I said, roof blows off of a barn. We waited to close until that was fixed. It's just easier to get it fixed at that point from representing the buyer. So when we do close, everything's perfect. We don't have to worry about it. So make sure you're aware of that. Default. If buyer fails to comply with this contract, buyer will be in default and seller may enforce specific performance seek such other relief as may be provided by law or both, or terminate this contract and receive the earnest money as liquidated damages, thereby releasing both parties from this contract. If seller fails to comply with this contract for any other reason, seller will be in default and buyer may enforce specific performance, seek such other relief as may be provided by law or both, or terminate this contract and receive the earnest money, thereby releasing both parties from this contract. Mediation. It is the policy of the state of Texas to encourage resolution of disputes through alternative dispute resolution procedures such as mediation. Any dispute between seller and buyer related to this contract which is not resolved through informal discussion will be submitted to a mutually acceptable mediation service or provider. The parties to the mediation shall bear the mediation costs equally. This paragraph does not preclude a party from seeking equitable relief from a court or competent jurisdiction. So pretty much if there is a dispute after the contract closes, it will head to mediation, hopefully get resolved in mediation before it goes to the courts. Attorney fees. A buyer, seller, listing broker, other broker, or escrow agent who prevails any legal proceedings related to this contract is entitled to recover reasonable attorney fees at all costs of such proceeding. The escrow agent is not a party to this contract and does not have liability for performance or non-performance of any party to this contract. They do not control if the buyer doesn't show up to close or the seller doesn't show up to close. They're not liable for interest on the earnest money and liable for the loss of any earnest money caused by the failure of any financial institution in which the earnest money has been deposited unless the financial institution is acting as escrow agent. Escrow agent may require any disbursement made in connection with this contract to be conditioned on escrow agent's collection of good funds acceptable to escrow agent. At closing, the earnest money must be applied first to any cash down payment, then to buyer's expenses, and any excess refunded to buyer. If no closing occurs, escrow agent may require written release of liability of the escrow agent from all parties before releasing any earnest money, and require payment of unpaid expenses incurred on behalf of a party. Authorized expenses from the earnest money payable to a party. Authorized expenses means expenses incurred by escrow agent on behalf of the party entitled to the earnest money that were authorized by this contract or that party. Upon termination of this contract, either party or the escrow agent may send a release of earnest money to each party, and the party shall execute counterparts of the release and deliver same to the escrow agent. If either party fails to execute the release, either party may make a written demand to the escrow agent for the earnest money. If only one party makes the written demand for the earnest money, escrow agent shall promptly provide a copy of the demand to the other party. If escrow agent does not receive written objections to the copy, if escrow agent does not receive written objection to the demand from the other party within 15 days, escrow agent may disperse the earnest money to the party making demand reduced by the amount of unpaid expenses incurred on behalf of the party receiving the earnest money, and the escrow agent may pay the same to the creditors. If escrow agent complies with the provisions of this paragraph, each party hereby releases escrow agent from all adverse claims related to the dispersal of the earnest money. So if something goes wrong, this deal falls through, say you represent the seller and you may not even be owed the earnest money, but you simply send, release of earnest money. You send a demand letter to the escrow agent. They have to send it off to the other party. If they do not get something back within 15 days, they may disperse the earnest money to the party making the demand. Never seen that happen, but it could happen according to the contract. Damages. Any party who wrongfully fails or refuses to sign a release acceptable to the escrow agent within 7 days of receipt of the request will be liable to the other party for damages, the earnest money, reasonable attorney fees, and all costs to suit. Pretty much at this point, if it gets to here, there should be attorneys involved, I would think. Notices. Escrow agents' notices will be effective when sent in compliance with paragraph 21. Notice of objection to the demand will be deemed effective upon receipt of escrow agent. So pretty much our goal is to stay away from this. That's the goal. Representations. All covenants, representations, and warranties in this contract survive closing. If any representation of seller in this contract is untrue on the closing date, seller will be in default. Unless expressly prohibited by written agreement, seller may continue to show the property, receive, negotiate, and accept backup offers. Federal tax requirements. If seller is a foreign person as defined by Internal Revenue Code and its regulations, or if seller fails to deliver an affidavit or a certificate of non-foreign status to buyer, the seller is not a foreign person, then buyer shall withhold from the sales proceeds an amount sufficient to comply with applicable tax law and deliver the same to the Internal Revenue Service together with appropriate tax forms. Internal Revenue Service regulations require filing written reports of currency in excess of specified amounts as received in the transaction. If this comes up, make sure that you get counsel from the title company, you get counsel from the CPAs, from your attorney to make sure that this is all done right. Paragraph 21, notices. All notices from one party to the other must be in writing and are effective when mailed to, hand delivered at, or transmitted by fax or electronic transmission as follows. Be sure you put your buyer's information in here. That's how parties will get a hold of them that are on the contract. That's how the escrow agent will get a hold of them. And I think in the last year or so, they put the buyer's agent, you can copy, put your email on there, right? I'd seen a long time ago where they would just put the buyer's agent email in there. Well, now they have a whole line for it. So make sure you put your client's information in there. And if you want to be added to those notices, make sure you put your email address in there as well. Agreement of parties. This contract contains the entire agreement of the parties, cannot be changed except by their written agreement. Addenda, which are a part of this contract, are. So I know we went over a ton of stuff above that we could say we could put in paragraph 22. So if any addendums onto the contract, this is where you'd put it. An addendum is adding to the contract. An amendment is amending the contract, making a change in the contract. And so all these are addendums. So you're adding stuff to the contract, whether third party finance addendum, it could be addendum for reservation of oil and gas and other minerals, lead-based paint addendum, the propane gas service system area down there in Central Texas, mainly, if that's part of it, fixture leases, right? Any of that stuff, right? If you did an Exhibit A for when we talked at the very beginning about if there's 20 different parcels and there's tons of legal descriptions, you would check other and put Exhibit A. You can have Exhibit B, you can have Exhibit C, you can have Exhibit D. Whatever additional addendums there are or exhibits that are not on here need to be put as other and put those in here. So they're a part of the contract. They are the contract. Consult an attorney before signing. TREC rules prohibit real estate brokers and sales agents from giving legal advice. Read this contract carefully. We are not attorneys, so please do not act like one. If your buyer or seller have an attorney, be sure you fill out that information. Executed the date of blank, 20 effective date. Broker fill in the date of final acceptance. Once both parties have signed and initialed the contract, so if they've initialed every page, and if there's any revisions of the contract, changes, you're crossing things out or putting anything in there, you need to make sure that your buyer and seller both initial by the changes. Once you have all the initials and all the signatures on the contract from both parties, that's when you can execute it. So if you're representing the buyer, you submit the contract with the buyer's initials on it, you send it to the seller initials everything. He may have changed a couple things on there. Maybe it's a sales price. If he changed the sales price, he would have crossed it out, put a new sales price, and then initialed right next to it. They'll send that contract back to you. You have your buyers initial it, and then you can execute the contract once all that's done. Once it's done, you make sure you send it out to the other party, the other agent. You want to send it to the title company. If you're representing a buyer, you want to make sure you send it to their lender. Anyone that is going to be a part of this contract needs to have the contract so they can start working. All right, so at the one of the last pages, so you have ratification of fee, where it says listing broker has agreed to pay other broker, could be 1%, 2%, 3%, 4%, whatever it is, your fee of the total sales price when listing broker's fee is received. Escrow agent is authorized and directed to pay other broker from listing broker's fee at closing. So you may have a question if you've ever seen this page, why there's a ratification of fee, then if you scroll down, there's all this whole stuff, there's all this right here talking about commissions. You will fill out the ratification of fee if your commission is already disclosed. So if that property is on the MLS, if that and it shows down there buyer's agent commission 3%, then you would use ratification of fee because it has been disclosed. So you would put 3% here, you would sign it, the other agent would sign it. If your fee has not been disclosed, that's when you'd use this down here. So upon closing the sale by seller to buyer of the property described in the contract to which this fee agreement is attached, seller will pay listing broker either a monetary amount or a percentage of the total sales price, and seller or buyer will pay other broker a cash fee or a percentage of the total sales price. Seller buyer authorizes and directs escrow agent to pay the brokers from the proceeds at closing. So once again, if your commission has already been disclosed, use ratification of fee. If your commission has not been disclosed, you would fill it in down here. One other thing, broker information agreement for payment of broker fees. If you represent the buyer, you put your information over here. Represent the seller, you put your information over here as a listing broker. If it's an intermediary, so if there's another agent in your office that is representing the buyer, then they would be the selling associate down here, and you would check seller and buyer act as an intermediary. And then you would have the intermediary relationship notice signed by both parties, and you'd have to add it up here on paragraph 22 of the contract, intermediary relationship notice, because that'd be part of the contract. Please be sure to fill out both agents' information. We are professionals. We want to set the standard and be the example of what a professional is as KW Land members. So fill out all the information. If you can't find the information, go to the Trek website, look their name up, fill their information out. If you still can't find it, call them and ask them what their information is. It's the respectful thing to do to fill both sides out. It shows that you're not lazy, and it shows that you are a professional. So if you're representing the seller, or most of the time you get the contract from the buyer, right? So you're going to fill out your information over here. Buyer only is buyer's agent. Fill out the listing information stuff. And if you don't know the licensed supervisor or listing associate, ask for it. Most of the time, if the property is on the MLS, that should be on there. You'd be able to fill all this information out. Very important and the respectful thing to do. Then obviously this down here is what's going to be the option fee receipt. The title company will fill out earnest money receipt. They'll receipt it. Contract receipt, title company will do it. And if there was additional earnest money, then they would receipt that as well. So that is the Texas Farm and Ranch contract. I hope you enjoyed this. I hope you learned something from it. Please give me feedback or comments if there's anything that you saw that I didn't address. But I appreciate your time and look forward to working with you.